luckily today we can see that is changing, not in Iran, but in many other countries, in the Middle East and in other countries. We see that people are uprising and trying to change this system, and the system that is oppressing them, and especially the law, the Islamic law and the law of religion has come under a big question mark. In Iran, if we're talking about the enlightenment of the Muslim world, this morning a lady was mentioning it, that has started. It has started long ago. And it's a big movement in that country. Believe me, if you find secularism more powerful in Iran, it's not at all surprising. There is an anti-religion movement, I can claim that, in a place like Iran, and it's very, very strong and powerful, and that has to be supported, worldwide. We need international support. If we need another French Revolution to fight religious law, to fight religious rule in the world, and if we want to fight Sharia laws in this country, here, if we want to fight any sort of intrusion of religion into our system, we should support people's movement in places like Iran. We should topple the Islamic government and any other governments that are solely governing under the religious laws, like Iranian government. And that fight has started, and we need international support for that. And we have to get rid of this system. We shouldn't really be scared of fighting against, saying our words, sure, I'll be finished in a minute. And we shouldn't be really scared. Some of the panelists mentioned that. We should be able to say that we are anti-religious. We don't want religion. Not in power, not in public space. We should be able to push it as much back to the corners of the houses as possible. I know that's not easy. People say, Muslim people say, well, this is my faith. I have to practice it in street. Otherwise, I'm not a Muslim. Sorry, this is a secular society, and we have all to respect that. Thank you.
Thank you, Suhaila. I'll pass over to Gita.
Thank you. Well, I know we've got a lot to get through, and I'm going to tell you what I want to say, and if I don't get to it, then please ask me the questions, because none of us have very long to speak. So I'm going to reflect a little bit on the secularism debate that took place this morning from the point of view of Women Against Fundamentalism, which I was a founder member of and I'm still active in, and then talk a little bit about debates in international law and also what's happening in the development field, where parallel legal systems are being spread, not least by British development agencies. And I think these are all huge threats to our, not only to our society here, but they are a specific British threat to societies abroad. And link that up with the issue of the cuts, which I'm sure are occupying a lot of our minds, and which we're going to have to deal with, we're going to, I hope, all be demonstrating against on the 26th of March. Women Against Fundamentalism was founded with the knowledge that Britain isn't actually a secular state. It was founded partly to campaign for the disestablishment of the Church of England, so the separation of church and state in England, because Britain formally is a Christian state. And the fact of it being a Christian state has been the reason that a lot of fundamentalists have used to make what we could call catch-up demands. So they've made equality demands because there is an established structure of Christians taking part in legislation. Bishops sit in the House of Lords. There are a huge number of state-funded Christian schools, and there's a lot of state provision for Christianity, both Church of England and Catholic, and Muslim demands and Sikh demands and a few Hindu demands and so on, and Jewish schools came in the wake of demands as equality demands. In other words, the form of equality in Britain was to make other religions as equal as Christianity. And I think that is one of the reasons why we really have to argue for maintaining not only the secular spaces, we have a very secularized society in many ways in Britain, but to make Britain a secular state, as of course the secular society has long done. But when we began to look at this, and Women Against Fundamentalism came from all parts of the world, what we found was that the secularism as we saw this morning, there are many different definitions of secularism, and most forms of secularism have some problem or other relating to women's rights. So you have the definition of the universal citizen that we got this morning of secularism, and that can have a problem in relation to both minority rights and women's rights, because where there are specific forms of discrimination, those may be eroded or wiped out by the idea that we are all common citizens. And I'm not criticizing the idea of common citizenship. I think it's one of the most powerful ideas that we can bring to the table of discussion in a discussion around secularism. But as one of the speakers pointed out, the secularism is a precondition for other demands around feminism and so on. It doesn't by itself guarantee anything, because both authoritarian states and non-authoritarian states are secular. They may or may not be racist and so on. And indeed, we see racist movements arising in the name of secularism as well, and we have to oppose those. So we have a very complicated task. But among those tasks, there is also the issue of the other kind of secularism, which is equal respect for religions, which is more, as it were, the Indian version of secularism. And that form inherits particularly from British colonial law, the idea that the state may be secular and certain space may be secular, as in respectful of all religions or welcoming of all religions or even non-religious, but the family is not. And family law is religious law in virtually every ex-British colony. And in some ex-French colonies as well, they had civil codes, but they had running alongside them religious codes as well. And so we find that secularism in many countries stops at the door of the family. And in fact, my friend Sohail Varaich, who is a male feminist and has been active in Pakistan for many years on women's issues, said, because he did a paper for me when I was at Amnesty International along with Cassandra Bolchin, who is chair of the Muslim Women's Network and works for a global justice and equality organization on Muslim family law called Musawa. They did a paper in which they showed that Sohail's expression was that if you want to look at discrimination in a society, look at the schedule of protections in the Constitution. This is the paradox of law that we have in relation to secularism and equality, which is that where certain groups are protected in the Constitution, for instance, as indigenous groups or minority religious groups, that law is not subjected to equality demands. So in other words, it's exempted from having to be equal. And where all religious law, where all civil law, family law is religious anyway, all of it is virtually exempted from equality demands. Nevertheless, because you will find people arguing that religious laws have reformed in many countries, and they have indeed reformed in many countries, but where do they reform? They reform only in the majority law. And my examples are mainly drawn from South Asia because that's the context I know best. They reform where there are movements for reform by the people who are in the majority. So for instance, in India, you had a reform of Hindu law, which is the Hindu Code Bill in the 1950s. And I want you to note that many of these reforms came before second wave feminism. They pre-existed second wave feminism. They were based on anti-colonial movements of women who had demanded their rights and often been disappointed by the national state, but nevertheless, looking at what fundamentalists have done to the state, as in Iran, we have to acknowledge that period, whether in Egypt or in Turkey or Iran or in all across South Asia, as movements where the modernization of the state meant not so much restriction of women, but a partial modernization and a partial moving towards equality. So you have Hindu law reforming in India, you have Muslim law reforming in Pakistan, and being at that time one of the more advanced family codes. And it went steadily backwards after that because penal law brought in stoning and so on. It never got carried out in Pakistan because there were huge movements against it, but it brought in stoning punishments, amputation punishments, apostasy, blasphemy, and so on. But you have these movements for reform in certain circumstances where even if the state isn't secular, there's a secularization of society, and that's absolutely crucial. Now, when you get to international law, you actually find that there is very, very little room for supporting secularism under international law. And I think this is one of the big problems for those of us who want to argue for secularism. And I very strongly say to all of us as a thing that we need to take forward is that as secularists, we need to mobilize in international spaces, just as we were talking about in the morning around Europe, a secular campaign in Europe. Because what's going on in spaces like the Human Rights Council, and I would say that the choices to walk away from these spaces is utterly tainted spaces where governments are able to really undermine even the idea or integrity of human rights, or you stay in them and take up these fights on issues of cultural values, on the attempt to make a kind of secular blasphemy law under defamation of religion, and many other issues like that. Now, what happens with international law is that you have, for instance, before the Human Rights Committee, one of the expert committees that monitors one of the conventions, you get individual women, probably Islamists, we don't know too much about them because you don't really know their background, who will present themselves to the council, to the committee, with a demand for protection from the state. So for instance, on the issue of veiling or something like this. So the issue becomes that of an autocratic state defending its state policies against the rights of the individual. And what you don't hear from is the rights of other individuals and whether the state is actually acting to protect individuals' rights or not. And of course, many of these states are not protecting anybody's rights, as in Uzbekistan or Tajikistan or other states like that. They're not particularly rights-based or protective states anyway. But what we have is that the cases often fall because the state is incapable of defending their positions as a position that's consistent with human rights law. And if they do succeed, and sometimes they have succeeded in the European Court, they succeed quite often under something called a margin of appreciation. That is, that states are allowed, and this is against the public and the private and the international spheres, if you like, states are allowed to make their own policies with regard to religion. So for instance, years ago, a blasphemy case that was brought, somebody charging that they should be allowed to publish work without censorship, from Britain, failed in the European Court because the state was given a margin of appreciation. It has a blasphemy law, it was allowed to uphold it. It's a long time since I looked that up, but that was a very unfortunate case. On the other hand, Turkey was allowed to keep its headscarf policy on this same margin of appreciation, even though many people would argue that it was unnecessary at a time when women are adult.